Good afternoon and welcome to our Educational Summit and Resource Summit session. We have today Ms. Shayna Siegel, who will be discussing Medicaid and estate planning in the state of New Jersey. She is one of the few certified elder care attorneys in Northern New Jersey who's been involved in long-term health care issues for over 25 years. She concentrates her practice in areas of elder care law, focusing on representing seniors, individuals with special needs, and their families in connection with life care planning. Also, public benefits, trust and estate planning, and long-term care advocacy. Thank you so much, Ms. Siegel, for your time today.
Of course. Thank you for having me, Melissa. I'm going to share my screen and hopefully you will all see it. Okay. All right, so today we're going to talk about New Jersey estate planning and long-term care and Medicaid. And I may point out here and there differences between New Jersey and New York as well. So I know that sometimes there are barriers to planning, and especially when you are a caregiver or you have a new diagnosis, there's a lot to deal with immediately, and estate planning isn't necessarily the first thing that comes to your mind. You're, meeting with doctors, dealing with the immediate issues, and, it can be really overwhelming to think about. A lot of times people just kind of put it off, or oftentimes think it's too late. It's not really important. We're not going to need Medicaid, so we're not going to think about these issues. So I want to just kind of go through and talk about what things I think are really important to get to and, provide some basic education on these issues. So when we're thinking about estate planning, we really, there's basically three areas that we're talking about here. So the first is appointing a power of attorney and a healthcare proxy. So these are, key individuals who can step into your shoes and assist with decision making. Outlining your healthcare wishes so that you know that they will be respected if there comes a time where you're not able to make your own healthcare decisions or express your wishes. And protecting your family by proper estate planning. So the first thing we'll talk about is the power of attorney. And I really encourage people to think about who do they want to step into their shoes. Now, sometimes this may be very obvious, right? You have a spouse, you have children who are very involved, but it's not always obvious. And a lot of times people will just choose, for instance, their oldest child, which may not necessarily be within their skill set. So I really do just encourage people to, first of all, appoint someone, appoint a backup, because unfortunately things happen. And also thinking about, what are the skills that somebody as a power of attorney needs and who in my life has those skills. The other thing is thinking about what information are they going to need to be able to act. So I had a client in my office earlier today who has some disability issues and and doesn't have any immediate family. And so we talked about, okay, you've named this person now. Do they know what all your bank accounts are? Do they know who your doctors are? Do they have a copy of your key to your house? Those kinds of things. So just making sure that it's not just about the document, it's really following through so that there's a full plan. When we're thinking about the actual document, of a power of attorney, there's really two immediate options to think about. One is a springing POA versus an immediate or a general durable. So the difference here is that the springing power of attorney does not come into effect immediately. So that means that there has to be some kind of threshold that is passed. And generally it is one or two doctors saying that you're incapable of managing your financial affairs. And that at that point that person would have the ability to act. And they would actually have to show, if they're going to go into the bank and present the power of attorney, they also have to present the doctor's letter stating that you're unable to act. That's obviously a protection so that somebody couldn't go in, while you're still capable of acting. But I really, caution you to think seriously about that distinction, because often there's not a clear path, or there's not a clear, light switch of incapacity, right? So it may be that you're having difficulty with speech. It may be that, you may have certain days where, you're just not able to handle certain tasks, just based on fatigue or based on, physical ability to get somewhere. So I think that it's that a general durable power of attorney is probably a better option if you do have somebody who you really trust to only use it, when the time is right. You can do a limited power of attorney as opposed to a general. We do our powers of attorney very broadly, but you can certainly limit that. For instance, you might have one just for banking, or just for real estate, or, whatever task is at hand. It's important to consider whether or not should be a gifting provision in the power of attorney, and if so, how broad that is. So for instance, if you have a power of attorney that was done maybe many years ago, maybe prior to a diagnosis, in that situation, it's probably going to have quite limited gifting, maybe up to the annual tax exempt amount of $17,000. And it probably says 15 because that's what it was several years ago. But the thing is that for some of the things that we're going to talk about later in terms of Medicaid planning, a broader ability to gift may be important. So that might be something that you would look to modify in your powers of attorney. The other thing to think about is, are you power of attorney for someone else? So for instance, for your spouse, and is it time for them to think about whether they need to have other agents to step in if you would not be able to do that as the individual with the ALS diagnosis? I just want to touch here also on powers on joint ownership. Sorry. A lot of people make accounts joint as a way of addressing this issue and making sure that someone can come in and be able to handle your banking. And that's fine, except you have to understand that the repercussions of that down the road. So if you make someone a joint owner on your bank account, that means that that is going to belong to them when you pass. It is not going to go through your estate. It's going to go directly to them. And that may not be what you want. That may not be consistent with your overall estate plan. So I think it's just a good idea to be aware of that issue. So healthcare decision-making is, another really important area to address. And, it's really important to document your wishes and have documents that reflect those wishes, which are going to, carry on if, again, when there comes a time when you're not able to share your wishes. So we have a healthcare proxy, which is a document where you name the agent and you say, I want this person to be able to make decisions for me if and when I'm no longer able to make decisions on my own. You then might have an instruction directive or a living will, which fills in the details of what decisions you might want that person to make. So when you might not want life-sustaining treatment, when you might or might not want a ventilator, all of those types of issues, feeding tubes. I find that a lot of times people's thoughts on these issues do evolve over time. So as they have experience with the illness, they may change their wishes, and that's okay. These documents can be changed, as you go along at any point. And in fact, some may even be able to be changed by your agent. So for instance, a post can be changed by your agent. HIPAA, I think we're all familiar with HIPAA. Just note that because you may have a number of people who you want to have information. Let's say, all of your children, you want to have information, but you've designated one of them as the proxy to actually be the person who signs consent forms and who is the conduit of speaking with the doctor. But this way, multiple people can get information. They just can't make decisions. And then post, which in New York, it's called MOLST, It's an order, a medical order, a practitioner's order on life-sustaining treatment. And the difference between that is that it is a medical order. So it becomes a part of your chart and would be honored anywhere without delay, in a sense of, if we do an advance directive, we do a we put DNR language, for instance, in our instruction directive. It's not until you have a medical order, whether that is a do not resuscitate order or a POLST, which may include a do not resuscitate or a variety of other potential orders, that it's really going to be acted on directly by the medical world. So I think that's really something very important to have a discussion with your physicians about when that may be appropriate. So when we think about estate planning, you're really looking at, a variety of goals. So we're looking at who's going to get your assets, potentially how they're going to be able to use that money, what their access, if there's any limitations. So for instance, you might have, young adults that you want them to access it over time, not all at once. There's a variety of tax issues that can come into play. In New Jersey, we don't have estate tax, but we have inheritance tax, which may be applicable depending on who your beneficiaries are. Of course, in New York, we do have estate tax. There's a lot of income tax issues and capital gains issues that come into play. Avoiding probate. A lot of people talk about avoiding probate. And in New Jersey, probate is really not a costly or a time, something that takes a real long time. So that may not be the most important goal in terms of how we structure our documents. Protecting from costs of long-term care, which of course we're going to talk to at length, and other legacy issues that there may be things, for instance, charities or other information you want to pass along. So I get asked all the time about revocable trusts or living trusts, as they're commonly known to. I swear, I think Suze Orman has been off the air for, 10 years, but I still get every day people come in and ask, well, Susie Orman says, but a revocable living trust is really a will substitute. And there are reasons why someone might want it. But it's not necessarily appropriate in New Jersey solely for the purpose of avoiding probate. The most common reason that I find that people want to and should want it is the third one here, which is out-of-state property. So what we don't want is to have our family dealing with probate in multiple states. And we can address that through a revocable living trust because it brings all property being held is considered to be New Jersey property if we're a New Jersey resident. So that can be really useful to avoid, you have a vacation home or whatever that you can avoid that difficulty. Another common concern is about financial management, and I find this a lot of times maybe in a second marriage situation or in another situation where all the assets are not passing to a spouse, or they are passing to a spouse, but there's other beneficiaries that they want to make sure do get the asset. So you might have a revocable trust because you're going to have then the trust designate that the spouse has access, but then what happens after the spouse's death. So that might be a reason to have a revocable living trust. When I have individuals who have disabilities and they are concerned about how they will be taken care of and who will be making decisions for them, a revocable living trust can be more expansive than a power of attorney. You can put a lot of things into it that directives that you might not put into a power of attorney. So that can sometimes be a reason to have a revocable living trust. Similarly, with people who have children who they don't want there to be any gap, even if it's only, 2 weeks, a month, to 2 months, you don't want to have that gap in access to funds, then a revocable living trust might be appropriate for those people. We talked about out-of-state property, different holdings, all of these reasons, but there is not a tax advantage. And as I said, probate is not particularly onerous. So that hopefully will kind of help you to make that decision in terms of whether or not it's something that you would need in your particular estate plan. Now, an irrevocable trust, we could really talk about irrevocable trust all day, but some of the things that may be particularly relevant to you in potentially making an irrevocable trust. So this would be a Medicaid asset protection trust. That is a trust that is created typically 5 years before the expectation of needing Medicaid. So, that may or may not be relevant in the context of your illness or your loved one's illness, but that would be one potential use for an irrevocable trust. Sometimes it can be appropriate for financial management. We have certain types of trusts in an IRA setting. We have a trust for minors. Often if we have, minor children or vulnerable adults who are going to inherit, we would want a trust involved in that situation. There are situations where trust can be very helpful for creditor protection. We're going to talk about special needs trust on the next slide. So that's a particular subset of irrevocable trust. And again, in the second marriage or tax planning situations, it might be appropriate to have an irrevocable trust. So besides the fact that they are revocable or not revocable, the difference between a revocable trust and an irrevocable trust is that an irrevocable trust is a separate entity. So it is a separate taxable entity from you, which means that those assets are then moved off of your kind of balance sheet. Whereas with a living trust, that's still you. It's still using your social security number. It's still taxable to you, and it's still available to a creditor. So it's not any distinction with a revocable trust in terms of availability, whereas it really is with an irrevocable trust. So special needs trust. So a special needs trust may be something that would be, relevant and appropriate for an individual with a disability, particularly if we're dealing with someone who is under age 65. So we do this for asset management purposes, but also very much for public benefits purposes, because we can put assets into a first party trust. So these would be our own assets. So if I am an individual with a disability and I want to place some of my own assets into a trust, that would be a first party trust, and I can do so and become Medicaid eligible. So if I had $500,000 and I wanted to go onto Medicaid sooner rather than later, I could put that money into my own first party special needs trust and then go on to Medicaid immediately. If I am under age 65, I can do that. So, but when we think about doing that, we really need to think about, well, how much of that money is going to be needed for my things that Medicaid isn't going to cover. So for instance, I might have equipment or, other expenses that Medicaid is not covering that I want to put money aside for. But every penny that you put into that first party trust, Medicaid does ultimately have a claim after your passing to it. So very often I will, counsel as to when we're doing an asset protection plan, how much is going to go into a first party trust versus how much is going to stay with the spouse or be gifted in some other means. And so we kind of, have to balance those issues. A third party trust is where someone else is putting money aside, their own money, for the benefit of another individual with a disability. So for instance, if you have a family member, parents or siblings, for instance, who may want to create a third party trust for the benefit of you as the individual with a disability. And that could be in their will, that could be as a standalone trust. And in that situation, Medicaid does not have a claim to those funds. So that can be, really important if, for instance, somebody in your life wants to leave assets to you. It's really important that they do so through a trust and not directly. Because then you end up with this, situation of making those assets available to Medicaid. And I would just really caution to be careful about making sure that all of the assets, I've had situations where people create a third-party trust, but they forget certain assets like their retirement or an annuity, and those end up still being left directly to the individual with a disability. So if that's a scenario that's relevant, just make sure that all of the assets that are meant to go in, do make it there. Okay, so let's now change gears and talk about long-term care. So this is just a little bit of a sobering slide in terms of the cost of healthcare. We've seen an enormous increase in the cost since COVID, and particularly with home health, which many of you may have experienced already. So, this just gives you a sense of the rates. So you can see that with rates like that obviously, you can very quickly run through one's life savings. Sorry, just hit that by accident. So what are some of the things to consider in terms of paying for long-term care? Well, you may have Medicare, whether you've reached that at age 65 or if you've reached that as a result of your disability. But that really is a quite a limited benefit in terms of long-term care costs. So, it may pay for some home care, and of course it's going to cover hospital and a lot of your therapies, but it's not really going to provide coverage for the kind of home health care for ADLs that you might need or for facility options. Many people end up looking as a result to private pay, long-term care insurance, if you had that prior to diagnosis, and we'll talk about veterans benefits and Medicaid. So I just want to briefly touch on veterans benefits here, and then we'll move over into Medicaid. So you may or may not know that there is presumptive eligibility for ALS for service-connected compensation. So if the individual with a disability is a veteran, that's something you would certainly want to take a look at. And in addition to the service-connected compensation, there is a special compensation add-on that may be appropriate. So that can be, for a small segment of individuals, that can be really powerful amount as those compensation payments can be substantial. Veterans benefits, if there wasn't a service connection, if we're talking about, for instance, maybe even a spouse of a veteran, we may also be able to have benefits for someone who is a spouse of a veteran. And that would be if they need assistance with ADLs. In any of these veterans benefit situation, it's important to really look at Medicaid as an overlay with veterans benefits and how the two of them interact, because sometimes the two of them don't interact well, the two programs don't interact well, and you may spend time dealing with getting veterans benefits only to find out that, well, it wasn't really relevant if we're going to need Medicaid as well. So, those are just things to think about. There are other veterans programs and veterans facilities that may be relevant as well. Again, both for if the individual with the disability was a veteran, as well as for someone who is a spouse of a veteran. Okay, so let's talk about Medicaid. Medicaid is a means-tested program, which means that it is traditionally for people of limited means. But because it does provide broad coverage of home health care and skilled nursing services, whether that's at home, in an assisted living, or in a nursing home, it is a program that is used by a wide swath of individuals who need that care. So there is medical eligibility as well as financial eligibility for the program that in New Jersey, which would typically cover the type of coverage that we are looking at, which is MLTSS. There are some people who are on Affordable Care Act Medicaid, who that's kind of a different program that does also cover nursing services. But primarily when we see individuals who are looking at long-term care Medicaid, they're going through the MLTSS, which is Managed Long-Term Services and Supports. And so the eligibility and the rules that I'm going to be talking about today are focused on that program. We do also have, I will mention, because this can be relevant in early stages of the disease, we do have a Medicaid workability program. So if you are still able to work some, that is, can be an option for that period. Okay, so resources. In the Medicaid applicant's name, the individual must have less than $2,000 in their name. So obviously, we're talking about having to take some action in order to get to where you would be Medicaid eligible, and we'll talk about what those things might be. There is no cap. This is one thing that people often don't understand. They think that, oh, I have, $3,500 in disability income monthly, and so therefore I can't possibly be eligible for Medicaid. And that's not true. I have clients who have, $6,000, $7,000 a month of income, and they can still receive Medicaid. But there is a cost share in that situation. So your funds, your monthly income would go into a bank account called a qualified income trust. There would be a budget as to how those funds are spent, and some portion of them would end up being paid to Medicaid or to a facility as a cost share. There are a number of resources that would be exempt. So if you're going to be receiving Medicaid living at home, the primary residence would be exempt, or even if you're looking at going into a facility, if there is a spouse or a minor child living in the home, then that is going to be an exempt resource. An irrevocable funeral trust is one resource that a lot of people do as they're spending down. Personal property is not considered. A car might be in many instances. If you would not be using a car anymore, you're going to be in a facility, then that would not be exempt, except for if the spouse is using it. But the primary residence is obviously the largest exempt resource that we would be talking about, and we'll talk about more. So where you are married, so if we have a healthy spouse and an ill spouse, that spouse that it's commonly referred to in the Medicaid language is the community spouse, because they are staying in the community. They are able to retain 1/2 of the couple's total resources, but there is a cap on that of $137,480. So that means if you have, anywhere in excess of, twice that, a little under 300,000, then the rest of those assets need to be spent down in some way prior to the ill spouse being eligible for Medicaid. And that's really where the asset protection planning comes in, because, you're certainly not going to want to just spend those assets down. In most cases, there are things that we can do that would allow the healthy spouse to benefit from those assets. So some of those assets might go into a first party special needs trust. Some of the assets might go to, for instance, paying down a mortgage or eliminating a mortgage. Some I've seen people who, increase their, purchase a more expensive home, and some other things that we'll talk about in terms of using the income rules. So, the interesting thing about income as opposed to assets. So when Medicaid looks at a couple's assets, they look at them together and they say, okay, anything over that spousal allowance amount needs to be spent, right? But for income, they look separately. So they look only at the income of the applicant, and they say if the applicant's income is over this threshold, which changes every year, then it is an issue. It must be deposited into that qualified income trust bank account that we talked about, and it may be subject to a cost share. Although if there is a spouse, that spouse may be able to keep some of that income as well. But the community spouse keeps all of their income. So, I'll very often have situations where the healthy spouse is still working, making a very, good income, and that's okay. The income is never the issue. It's just that often that's accompanied by assets, and the assets are what we need to deal with in order to get the individual onto Medicaid. Where I have a more traditional situation with an older couple, sometimes the community spouse may not have very substantial income. Maybe they have Social Security, it's more limited, and they may be entitled to some of their ill spouse's income to supplement their own. So that's something we always looked at. So because income of the community spouse is excluded, is not looked at, that allows us to use this as a way to put together an asset protection plan. So there are specialized annuity products that we use where we take an asset. So let's say you have, $300,000 over the community spouse allowance, that you could take that $300,000, put it in the community spouse's name in an annuity product that gives that person income. And now all of a sudden that $300,000 is not on the balance sheet because it's income and we're not looking at income. So, that can be one way that we'll very often be able to protect where there is a spouse. So, as you may know, when we're looking at Medicaid at the point that you're going to be making application, they are going to be looking at any transfers that were made in the 5 years prior to applying for Medicaid. And they are looking for any place that there was a gift that was made for less than fair market value. So whether that was an outright gift, you paid for something for someone, or you were trying to protect assets, so you gifted them to someone, or where you maybe just did the things that you would normally do, paying for a family member's wedding, or making your donations to your church. Medicaid looks at all of those with the default, assuming that they were all made for the purpose of securing Medicaid eligibility. So that's sort of their initial presumption, and they apply a penalty for any transfers that were made. And the penalty is based on the value of the gift. So for instance, if I gave $10,000 to my child, then then that would be equal to 1 month penalty. So there would be 1 month when I would otherwise be eligible for Medicaid that they would consider me not eligible for Medicaid. So it can delay eligibility. Now, in the situation where you have an illness that, comes on fairly quickly, and you may have made gifts not having any idea that you were going to need Medicaid, 4 or 5 years later, you can overcome the presumption in that situation. So you can show that at the time that the gift was made, that there was no expectation, that you did not know that you might need Medicaid. And so therefore, they would not apply the penalty to that particular gift. They also sometimes don't apply penalties to gifts if they're of a smaller amount. It really, unfortunately, in New Jersey, it can be literally county to county, caseworker to caseworker, how they apply that. But generally, if we're talking about smaller gifts under $1,000, they're not going to get aggressive about those. But they can choose to add those gifts up over time and apply a penalty for them. So it's certainly something to be aware of, but not necessarily going to be a major problem. So, so this is just kind of a little bit more detail on the idea of the annuity. So as I mentioned, annuity takes an asset and converts it into income. And so we can use that to provide income for a spouse, to be able to protect their lifestyle, to be able to give them, essentially give them back assets. You take an asset, you turn it into an income stream, it pays over to them over a period of, let's say, 2 years, and then 2 years later, they have that asset back in their bank account. So, it's a way of kind of circumventing the asset rules. And that can obviously be a wonderful thing for where there's a spouse. We also can use it in a non-spousal situation. We'll do that to be able to do gifting where maybe a 5-year plan isn't going to be an option. So, in a situation where we're looking at Medicaid on a much shorter time frame, it may make sense to still want to do some gifting. And in that scenario, we could do that using an annuity. And essentially, the way the annuity works in that situation is if Medicaid's going to apply a penalty, whether it's for prior gifts that maybe you gave and that, Medicaid now wants to apply a penalty, or for gifts that you're going to make as part of this asset protection plan, we calculate what the penalty would be, and then we purchase an annuity that would pay during that, while that penalty is running. So for instance, if there were $50,000 of gifts that were made, I would gift out, it's not really a gift. I would set aside $50,000 to purchase an annuity, apply for Medicaid that, early when I still had that $50,000, and then that annuity would pay out for 5 months while the penalty is running, so that's going to pay for my care during that 5 months. So, it's just a tool that we use to be able to kind of get Medicaid sooner without having to spend every penny, and then be faced with a situation where, there's no funds left. In terms of transfers, a couple of kind of areas of transfers to think about. You can transfer between spouses. Now, this may or may not be helpful, because if you're transferring cash, they're still going to look at the money if it's in the spouse's name. But that could be important just to get them, maybe all of the money is joint. We want to get it out of the applicant's name and into the spouse's name. And then the spouse can, undertake an asset protection plan from there. Transfers to a disabled individual. So, we might have a situation where there is a child with a disability in the family or a sibling with a disability, and that in that situation, you can go on to Medicaid when you would still have assets simply by transferring those assets to the individual with the disability or to a trust for that person. So, whether that person might be for yourself for a special needs trust, or it might be for another person who has a disability that you want to provide for. And that could be outright or to a trust. For yourself, it would obviously be a self-settled first party special needs trust. That's only to age 65 in New Jersey. And then we have transfers for value, and that, you think, well, how does that help me, right? I'm giving something to someone, but they're paying for it. But it can be very useful because the actual value and the Medicaid value may not be the same. So, for instance, I had a situation where there was a piece of property that was very marketable, but its Medicaid value its tax assessed value was substantially less. So we were able to transfer that property. The family paid the assessed value, but then got something that was actually, worth substantially more. Medicaid is getting a little bit more savvy on that piece. They're now looking to Zillow and things like that for value, but according to the regulations, the value is that tax assessed value. So that can be another piece that can be where this can be really useful is, it's a little bit hard to think about, but if you have an individual with a life insurance policy, and the death benefit of that life insurance policy may be, let's say, 100,000. But the cash value of that life insurance policy may be substantially less. So maybe the cash value is only $10,000. Someone in the family can purchase that for the $10,000, and that's considered a transfer for value. So if they did have the funds to do that, you're getting an asset which will ultimately be worth 100 for 10. So, those kinds of things can sometimes, come up and be helpful for people. Another segment of transfers that I'd like to make sure that people know about are transfers of the home. So, as I said, if you're living in the home, then it's exempt. If your spouse is living in the home, it's exempt. Or your minor child, but in certain other instances, it's not going to be exempt, and there's going to be a lien that is building up against that. So if you're at home, it's exempt in that, like, they're not going to force it to be sold, but they will be placing a lien against it if it's in your name. If there's a spouse, you could transfer it to your spouse's name in order to avoid the lien. But if you're a single individual, and you're receiving Medicaid services at home, you're going to have a lien that's gathering against that home. So some of the options that are available to you to protect the home are, we talked about spouse and minor child. Disabled child, is another one. You can transfer a house to a child with a disability. We also have a caretaker child situation. So for instance, if you are living in the home, your child moves into the home with you, lives there with you for 2 years and provides care for you, then that home can be transferred to that child after 2 years. There are a lot of rules and a lot of case laws surrounding that. So if that's something that you are considering as an option, you really need to work with an elder law attorney who is very familiar with the cases and the way that's handled by the Medicaid agency, because they're quite aggressive in trying to argue that this exception doesn't apply. So that's one piece. The other that sometimes I see is a sibling with equity. So for instance, you have 2 siblings who were left the home together, and and one becomes ill, they go onto Medicaid, the house can be transferred to the other sibling so that they have it outright. So that's, another thing that may be available in certain circumstances. So that is kind of what I have. Certainly any questions that anybody has, I'm happy to answer at this point.
We do have one question. They're asking, are you saying an annuity is not subject to the 5-year look back?
So that is correct. You can do this annuity transaction if you, within the 5 years, I do it usually, 30 days before I'm applying for Medicaid. And that's fine, because you're purchasing something that has a value. So you're going to put $100,000 into an annuity and they're going to pay you $10,000 a month for 10 months. So you're getting your money back. It's just the feature of it that it converts an asset to an income stream is very useful for our purposes.
And also, can a disabled person pay spouse for caregiving in New Jersey?
So the way that would be done would be through typically it would be done through going onto Medicaid, applying for the PPP program, and then paying that spouse through that program. And previously you could not have a spouse, but now you can because there's such a shortage. So so that would be really the only option of potentially doing that.
Mm-hmm.
There are a lot of rules related to that. Sorry, I was just going to say in terms of the spouse has to take it as income, and so whether it actually works or not is a whole nother question.
Mm-hmm. And a question is, can an executor appoint someone else to handle in the state, and how difficult would that process be?
So it depends on a couple of things. So, the first thing is, when are they appointing, right? So an executor can renounce and say, you know what, I can't take on this role. And if there is another person who is listed as sort of the next in line on the document, then that person would apply to take over as successor. And even if you didn't undertake that and renounce, that can happen based on disability, right? So if somebody gets a diagnosis, they were acting as executor, you can show the court that this person needs to step in. But in a less formal way, you can designate someone to take on the activities. So whether if you're working with a law firm or you're working with someone else, they can do a lot of the legwork of being the executor tasks, if you're still able to sign off to do, to whatever, write the final checks or whatever it is. So, there may be a way to do it in a less formal way.
Okay. Good. Also, going back to the first question about the 5-year look back with annuity, this person had another additional question to it. What type of annuity would work for question 1?
So it's a very specialized product. It is not something that you're going to just get on the market unless you're really working with someone that, understands Medicaid compliant annuities, because there's all kinds of rules that apply to them. So they're typically what we would call a SPIA, a single premium immediate annuities, but they're not just any old SPIA. They have to they have to be for a certain length of time. They have to be completely not reversible, so irrevocable, not assignable, nothing that you can change in any way, which typically SPIAs you can be changed. So we have to have specific language written into the contract. And Medicaid has to be listed as the final beneficiary on the annuity. Now, that doesn't mean that Medicaid's ultimately going to get money, because in many instances of how we use it, there's never going to be a scenario that Medicaid's going to get those funds, but it's still required to be listed on the annuity. So, we'll work with financial advisors to, to see if the annuity that clients may already have may be able to be changed, or we'll work with them to purchase an annuity, working with the financial advisor, or we have our own Medicaid compliant companies that we work with, on a regular basis. So just depending on what the scenario is.
Any other questions before we wrap it up? Just looking at the 2 pages. Let me just switch out here. I don't see any other questions.
Okay, great.
Yeah, thank
Well,
you.
if anybody does have any questions, you should have my information and can reach me through Norris McLaughlin. And happy to have this opportunity to talk to you.
And I thank you so much. And if you guys in the next around 4:30 at 4:30, we're gonna have nutrition and ALS with Cheyenne Tate, who is a registered dietitian with the VA in the Bronx. So hope to see everyone there. And thank you, Ms. Siegel.
Thank you.
Have a great day.
Bye-bye.
Bye, guys.